record.
Item number 12 on the first appearance docket, Your Honor, is Stephanie McCrea.
Correct.
Is your true name Stephanie Erin McCrea?
McCrae, yes.
First name spelled Stephanie?
Yes.
Middle name Erin?
Yes.
And last name Mccrea?
Yes.
And your date of birth?
3/27/79.
Making first appearance this morning, Your Honor, on charges of rape of a child in the third degree, forfeit, and tampering with a witness.
All right, Ms. McCrae, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney assist in your defense. Mr. Thayer, I'm assuming you're here at least as a courtesy this morning, or have you been retained yet?
We're retained, Your Honor.
All right, thank you. One moment then while I review the probable cause. The indication here, rape of a child, third degree, tampering with a witness, sexual misconduct with minor 1 and 2. All right, court finds probable cause established. Position on release.
Your Honor, the state's asking for $500,000 bail. The argument against bail in this matter will be that the defendant was employed with the same employer for a long period of time. She has ties to the community. But we'd indicate to the court that this is a very serious crime for several reasons. And this person was trusted with the children of the Evergreen School District. Parents would send their kids to school thinking that they'll be safe, including extracurricular activities outside of the school. And in this case, this teacher specifically took advantage of students in that way. The students spent time with her outside of school, including going to the movies and other activities that were not school-related. Specifically in this case, one of the incidents took place at a time when she did have the trust of the parents, did take the kids out to the movies, and met this victim in her home during that time and had sexual contact with him.
I'm assuming she's on leave of some kind then from that
She
job
is
this
on
time.
administrative leave, and I think that's a very important thing for the court to understand as well. After she was placed on administrative leave, she continued, and she knew that the allegations had been brought to the police. She continued to have contact with this victim. She had made a contingency plan that if they were ever contacted by law enforcement, that they were to create a fake Facebook page with aliases, which they did. She coached him on how to respond to law enforcement if he was contacted. She also was very manipulative of this victim. She indicated to him that she was going to commit suicide and attempted suicide. And so we think that this is a really significant crime, and the court should take it very seriously. Unfortunately, we've had opportunities to hear from people who don't think it's as serious because the victim in this case is a male, but any parent would understand that the fact that whether the victim is a male or a female, this is extremely serious. She was in a position of trust and should be treated thus wise.
And some of the facts that you're mentioning there aren't specifically in the PC statement, but I'm taking those as representations by
Yes, Your
counsel
Honor.
with the duty of candor to the court.
Yes,
So,
absolutely.
Mr. Thayer.
Well, Your Honor, Stephanie's 35 years of age. She has no prior criminal record. She was born and raised in Portland. Went to
Has at
school.
least one child?
One has one child. Went to
Old?
I think he's 9.
Yes.
He's 9 years old. And she's never been in trouble before in her life. She taught at Evergreen High School for 8 years. There was no problem until this situation arose. It's situational. There's no reason to believe that she would be a risk to reoffend if she were released on recognizance. Rule 3.2 creates a presumption of release on recognizance unless the state can establish that she's a risk to reoffend or is a flight risk. And we know she's not a flight risk because she voluntarily surrendered yesterday after I made arrangements with the detective to have her turn herself in down at the Sallyport at the sheriff's office.
Does she own her home?
She
No, Your Honor.
no, she doesn't own her home, but she has parents and family and strong community ties. There's public support for her, family support for her, and based on the presumption, I think that there's no, and the other thing is, counsel mentioned that there was some kind of communication between her and the alleged victim regarding what to say or what to do, but that was before she was brought before the court, and if she's instructed not to do that as a condition of release, no contact, of course, there's no reason to think that she wouldn't follow the court's directive. So I think she should be released on supervised release. The request for $500,000 bail is political, pretty transparently political.
Well, one of the factors that the court can consider under Rule 3.2 is protection of the community. And so I guess one question I would put to you is, aside from a sexual assault protection order, which is being requested, what other assurances can be provided that during the pendency of this case that, I mean, obviously if she's on administrative leave or whatever from the school, she's not going to be there.
Right.
It may be episodic or with this one particular alleged victim. But I guess the court is asking if there are, what other assurances or proposals would there be to help mitigate on that particular factor in Rule 3.2, protection of the community?
Well, there's no showing that she's likely to reoffend. There's, you know, this is the only thing she's ever been brought to court for before in her life. It was obviously situational. So as far as assurances, the court can require her to maintain residence with someone like her mother, or she could live with relatives. No contact with the alleged victim, of course. No drugs or alcohol. The screening done by corrections shows that there's no drug or alcohol problem. Maintain contact with counsel, the usual things. I mean, there's no showing here that we have to any cause to have any concern. And of course, if anything happens, she can be brought back and redirected.
Your Honor, if I may.
You may.
The court asked, I mean, one of the things that was mentioned was the fact that she has no criminal history, and the court is well aware in these cases that oftentimes in these types of cases there is no criminal history. What we do know is that this defendant had access to lots of students during the time that she was trusted with these students. Also, we also know that while on administrative leave, while contacted by her agency, after doing that, she still made contact with this victim, and that's
in fairness, that's not in the PC statement, though. I don't have an indication of contact after that. I have some indication.
Your Honor, I think that the court can look at things outside of the PC statement, and it is with candor that I indicate this to the court. She was placed on paid administrative leave, made up a fake Facebook account with this victim, and continued to talk to him about issues, including promises of them being together forever. These are very serious allegations, and I think that the court needs to look at them as such.
Right, and I think that the court can prohibit her from having contact or using the internet, using media devices, if the court feels that that concern is going to be valid going forward, which I don't. I can assure the court she's going to follow the directions of the court, the conditions imposed. This is a good supervised release case, and we hope the court will do that.
All right, the court takes into account the factors under Rule 3.2. There's, frankly, factors weighing on both sides, sort of all over the map on this. Under the circumstances, the court's going to set bail at $40,000 plus conditions. I am going to enter a sexual assault protection order, ma'am, with respect to the alleged victim, initials DWF. Let me make very clear, it's going to be here in writing. But this order will prohibit any kind of contact, that is direct, indirect, electronic, through third parties, you name it. This court will not tolerate, given the nature of the circumstances, they're somewhat explosive, this court will not entertain any deviation from that order whatsoever. So any violation of that whatsoever will result in you being brought back before the court and having to have those addressed. So while these charges are pending, absolutely no contact with that alleged victim. You'll get a copy of that order. I'm also going to include and restrict use of electronic, internet, and media. I think that is appropriate under the circumstances. We're going to set over to February 11 for arraignment.
Your Honor,
Judge, do you have a note or a release order?
we usually set conditions at the time bail is set.
Bail's going to be set today.
If you want to go back and work with Ms. Welch and set conditions, we can come back and wrap up a release
All right.
order.
Thanks, Court.
Your Honor, is she able to have contact with her minor son at this time, or is there no contact with minors?
state requesting any restriction on her contact with her own child?
No, but we are asking for no contact with all other minors.
Absolutely no contact with other minors other than your own child while the charges are pending. Okay?
All right.
Thank you.
Let's go back and we'll, work with release here to get.
Item number 15 on the first appearance docket is Lee Whitaker. Mr. Whitaker is in custody. He's not been transported down at this time. At this time, the state is handing forward a motion in order for exoneration. Your Honor, I have asked the jail to strike him from the transport list.
Stampede, huh? All right, I've signed the order of exoneration.
Item number 11 on the first appearance docket is Bethany McCauley.
Macaulay. Red card, face the judge only. I don't know when
Is your true name Bethany Ann McCauley?
Yeah.
You have to answer yes or no.
Yes.
And your first name, is it spelled Bethany?
Yes.
And your middle name Ann?
Yes.
And your last name Mcauley?
Yes.
And your date of birth?
1792.
Making first appearance this morning on charges of burglary in the second degree.
All right, Ms. McCauley, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges that are brought, and you have the right to an attorney represent you in your defense. You do qualify for a court-appointed attorney. Would you like me to appoint one for
Yes.
you? So Diane Greco. She's going to come forward while I review the probable cause statement. All right, probable cause established. Position on release.
Here on the state's requesting $20,000 bail plus conditions. It does appear that she has a substantial criminal history out of the state of Washington. This does include felony history as well. Does have at least one prior conviction for felony bail jumping, at least 9 prior probation violations, 19 prior warrants having been issued for her arrest with a history of failing to appear. Supervised release could not verify any residence or reference information. For those reasons, Your Honor, the state would submit $20,000 bail as appropriate.
Your Honor, at this time it looks like they were unable to verify address only because apparently they were not able to make contact with her parents. However, I just would note, based on the charge, it looks like it has to do with a theft in the amount of, well, less than $10. We would ask the court to consider a bond significantly less upon a verified address.
All right, thank you. The court, even though it's charged as a burglary, it does appear to be sort of a theft and trespass turned into burglary. $10,000 plus conditions seems appropriate. We'll set over to the 11th at 9 a.m. for arraignment.
How much will he have to pay?
Go ahead, we're going to step back. Go ahead and take it. No time.
Thank you, sir.
Item number 14 on the first appearance docket is Stephen Center.
Right, I'm sorry. Center.
Your true name is Stephen Andrew Lewis Center.
Yes, ma'am.
First name is spelled Stephen.
Yes, ma'am.
Middle name Andrew.
Yes, ma'am.
Lews.
Yes, ma'am.
And last name Senter.
Yes, ma'am.
And your date of birth?
7/14/85.
Making first appearance this morning on charges of possession of a controlled substance, methamphetamine.
Thank you, Mr. Center. You have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges that are brought, and you have the right to an attorney. Do you have your own attorney at this time?
I do not have an attorney.
Would you like me to appoint one for you?
Yes, sir.
Susan Stauffer. She's going to come forward while I review the probable cause, PCS meth.
Good morning.
Good morning.
Don't say anything about the charges. We're going to talk about break and live and release in case.
So what?
Don't say anything about
Okay, probable cause established. Position on release.
The State's requesting $10,000 bail plus conditions. It does appear that he has a criminal history out of the state of Washington, and it does include felony history, at least 2 prior possession of controlled substances convictions, one from 2014, one from 2012. Does have a history of failing to appear, at least 9 prior warrants having been issued, at least 9 prior probation violations. Supervised release was not able to verify any residence or reference information. For those reasons, Your Honor, the state would submit $10,000 bill as appropriate.
Your Honor, at this time, pending determination of any other suitable residence for my client, I would just ask for perhaps a $2,000 bail, given the nature of the PC probable cause statement and the allegations here.
I think given some of the history and the problems with compliance with court orders, 7,500 plus conditions is appropriate. February 11, 9 a.m. for your arraignment, sir. That's your next court date.
Okay, thank you, Your Honor. Let's have a seat.
Item number 10 on the first appearance docket is Jeffrey Mahar.
Mahar.
Pull your pants up. What's your name? Jeffrey John Mahar.
Mayor, yes.
First name spelled Jeffrey.
Yep.
Middle name John.
Yep.
And your last name Maher.
That's correct.
And your date of birth?
3/27/85.
Thank you for first appearance this morning on charges of possession of a controlled substance, methamphetamine, criminal impersonation in the first degree, and possession of stolen property in the second degree.
Okay, Mr. Maher, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney assist in your defense. Do you have your own attorney at this time?
No.
You do qualify for court appointed. Would you like me to appoint one for you?
Sure.
Okay, Christopher Dumm. He's going to come forward while I review the probable cause.
Jeffrey? No. My name's Chris. There's not much to this appearance today, probably not.
Yeah.
Probable cause established. Position on release.
The state's requesting $20,000 bail plus conditions. He does have a criminal history out of the state of Washington. That does include felony history. Most recent conviction being from 2014, of possession of stolen property in the second degree. Does have at least 2 prior possession of stolen property in the second degree convictions, Your Honor. He had a DOC warrant at the time of his arrest. He has a criminal history out of the state of Washington, Oregon, and Alabama. 4 of his 11 Washington cases have all gone to warrant status. Does have prior probation violations as well as prior failures to appear. Supervised release was unable to verify any reference or residence information. For those reasons, Your Honor, the state would submit $20,000 bail as appropriate.
Do you have anybody who can post anything for you?
Possibly, probably not.
Okay. My client probably doesn't have any funds to post any amount of bail anyway, Your Honor. We'll probably reserve that for arraignment if something changes.
All right. We're looking at basically Class C felonies there. Court's going to set it at $15,000 under the factors of Rule 3.2. Set over to February 11, 9 a.m. for your arraignment.
Your Honor, going back to item number 12 on the first appearance docket, Stephanie Gray.
Okay. All right. Yeah, thanks.
McCrae? She coming? All right, Ms. McCrae, have you gone over these release order conditions with Ms. Welch?
Yes, Your Honor.
You understand that if and when you post bail, that these are the conditions upon which you'll be released while your charges are pending trial.
Yes, Your Honor.
If you violate any of these conditions, your release can be revoked. You can be brought back into custody. You understand that?
Yes, Your Honor.
Okay, so these are very serious. We have already gone over some of them, but I want to cover some of these again. First of all, absolutely, positively, as a condition of this order, as well as a sexual assault protection order, no contact whatsoever with the alleged victim, initials DWF, date of birth 6/7/99. You're to report to the supervised release department over at the jail building. Don't just walk out the door if and when you do get released on bail. No contact whatsoever with minors other than your own son. You're to maintain residence at the designated address there. With that phone number, stay in touch with your attorney and make all your court appearances. When's your next court appearance, ma'am?
Your Honor, we haven't been given a new court appearance yet.
I think we set arraignment for February 11 at 9 a.m.
Yes, the court did.
Oh, excuse me.
So February 11 at 9 a.m. If you don't show up, well, actually, I wanted to also put the conditions on here as well. No use of the internet or electronic media. I'm sorry?
Oh, sorry, I was responding to him.
Uh-huh.
No use of
Nothing, Your
media should be on there.
Okay, that's what I need your attentions on. So no use of the internet or electronic media.
Oh, that's right. Judge, there was a concern raised by release that if she's, we need to know from the court if the court would allow her to drop off and pick her son up at school as long as she remains in her vehicle.
Your Honor, we would object to that simply because we don't think the public would be happy with that, but we'll defer to the court, of course.
I'm assuming it's a different school. The child is, what, 9 years old?
Correct, Your Honor.
Yeah,
He goes to private school.
Okay, so stay in the car. Do not go to or from the building itself. Child will be permitted to be picked up by the mother on that condition. Okay, so no use of internet or electronic media.
Right.
And then if you don't show up for your court dates, ma'am, that's not only a violation of this order, that's a new crime of bail jumping. You understand that?
Yes, Your Honor.
Okay, so we'll see you on February 11 at 9 a.m.
Thank the court.
I would just indicate that this is Mr. Hayes' case. He's in trial today, so you can have
All right.
Thank you.
Item number 13 on the first appearance docket is Alfonso Rivas.
This is
That's it for you. Okay. All right. Sometime call me tomorrow.
How do I pay my bill? How do I pay my bill?
Don't worry about it. It's already
It's
covered.
done.
Rivas. Red carpet facing Judge Olin.
Is your true name Alfonso Hernandez Rivas?
Yes, ma'am.
First name spelled Alfonso.
Yes.
And your middle name Hernandez.
Correct.
And your last name Rivas.
Yes.
And your date of birth?
10/16/79.
Thank you. First appearance this morning. I'm in charge of the possession of control of the substance with intent to deliver methamphetamine.
Okay, Mr. Rivas, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges that are brought, and you have the right to an attorney assist in your defense. You do qualify for court-appointed attorney. Would you like me to appoint one for you?
Yes, sir.
Okay, Diane Greco. She's going to come forward. Delivery of PCS methamphetamine is the indication. Okay, probable cause established. Positional release.
The state's requesting $50,000 bail plus conditions. It does appear that he does have a substantial criminal history out of the state of Washington, felony as well as misdemeanor history. He had at least 5 prior possession of controlled substance charges, two convictions being from 2013. Does have a conviction for felony bail jumping. Does have a history of failing to appear. Supervised release wasn't able to verify any residence or reference information. The indication is he is currently homeless. It does appear that he does not have a connection with the local area. Based on the nature of the charges and the dangerousness to the community, the state would submit the $50,000 bail as appropriate.
Your Honor, I think we'll reserve on bond.
Okay, $50,000 is bail at this time. Set over to February 11, 9 a.m. for your arraignment.
Items number 3 and 9 on the first appearance docket is Samuel Littlefield.
Littlefield.
So what's your name? Samuel Jose Littlefield?
It's Samuel Joseph Littlefield.
And your first name, is it spelled Samuel?
Yes, ma'am.
And middle name Joseph?
Yes, ma'am.
And last name Littlefield?
Yes, ma'am.
And your date of birth?
12/10 of 80.
You take your first appearance this morning, Your Honor, on charges of felony harassment and intimidating a public servant. Also has an existing case in which Ms. Ruley represents him. It looks like that's a Department 3 case.
Hold up, please.
It's actually Department 1 now.
Yeah, also, I want to.
Hold on. Department 1.
Today's the judge.
Man.
Do we use the Department 3 attorney group then?
Yes.
Okay. All right, Mr. Littlefield, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on these new charges, and you have the right to an attorney represent you. You have not yet qualified for a court-appointed attorney because of indication that there was a refusal to cooperate with the interview.
What do you mean interview?
Well, in order to qualify for a court-appointed attorney, you have to disclose what your assets and financial situation is. You have to meet the standards. Otherwise, you have to get
None
your
of this even happened, though, sir. I mean,
Sorry?
You're saying that I didn't cooperate or some type. Last
No,
night,
I'm
man,
not
I was
saying-
assaulted in front of a whole group of people when police officers took turns twisting my wrist.
Okay, we're not here to talk about that, sir.
What are we here to talk about?
Well, you haven't yet qualified for a court-appointed attorney. You have another charge, and Ms. Ruley represents you on that case?
I was beat up by 4 or 5 cops.
Sir, you're not hearing me, okay? We're not here to talk about that now.
This is weak, man.
Okay. You are represented by Ms. Ruley in the other case? Is she representing you in that case?
I just think it's flat wrong what you're doing.
All right.
You know it's corruption. You know what it's about.
He has no future court dates in that case, Your Honor, because he had a bench warrant outstanding on that case at the time of this arrest.
I have no bench
So he
warrants.
is making first appearance on that bench warrant as well.
We're going to transfer this case to Department 1.
This is
I'm going to appoint Ms. Ruley on this case as well. She'll be notified that she's been appointed, and you're going to get a slip of paper with her contact.
I didn't have any
Stop.
warrants.
Stop. You're going to get a slip of paper with her contact information. She's going to be notified that she's been appointed as your attorney.
Am I being released?
Right now, I'm going to review the probable cause to see if there is probable cause to hold you, sir, on this.
All right, thank you.
All right, court finds probable cause established. State's position on release.
Your Honor, with regard to the new case, the state's requesting $25,000 bail plus conditions. He did have a no bail hold initially on the 14-1013-116 matter. He had failed to appear for a change of plea date that was set. Does have a felony history out of the state of Washington. It looks like the most recent conviction out of the state of Washington being from 2010, a failure to register. Looks like he might be a failure to register a car, though, if I'm reading this correctly, so it may be a misdemeanor. Does have a history of failing to appear, supervised release. Didn't have any information with regard to residence or reference information. For those reasons, we would submit some $25,000 bail on this case is appropriate. We're also asking to revoke bail on the other case, Your Honor. Bail had been previously set at $10,000. We're asking to revoke that and reset bail in the amount of $20,000 for a total aggregate bill of $45,000 plus new conditions imposed.
All right, so do you wish to respond to the state's request regarding bail?
I wish to respond back to the fact that we're going back to when the last time I was here when they used false criminal history in front of you, as they did, and they're doing it again. So I don't really have a history of not showing up. They're using that as totally out of balance, and which was already corrected once, which you're still using. As far as the warrant goes, I wasn't aware that I had any warrants. I've been stopped twice. Nobody said I had any warrants. Then last night, I was walking home. I stopped and knocked on a door. Next thing I know, my wrists are being twisted multiply by different police officers, which I have. Let's just check this out, just so you have an understanding.
So you have the right to remain silent, and you probably.
Why can we only talk about me getting in trouble, man? We never talk about what's going on.
You need to talk to your attorney about that. Everything's being
It's
recorded.
bullshit, man.
We're trying to look out for your interests, sir. Everything you say is on record here.
I know it's on record, but why is it they keep coming up with these fake stuff instead of talking about really what's going on with me?
Here's what we're going to do. We're going to set bail at $20,000 on the new case. We're going to revoke on the previous case and impose an additional $10,000. We're going to set over to arraignment. We're going to set over to February 11, 9 a.m. for.
Then I have my boss's son in a cop car out in front of your place, man. You guys
Willie has been appointed as your attorney. You got your slip there. We'll see you on the 11th, sir. Thank you.
Just a moment so we can do memorandum so the jail records is clear on what bail is.
A little angry. He didn't like his breakfast.
Number 7 on the criminal docket is Matthew Souter.
I don't want this shit at all. This is bullshit, man. Fucked up, man. I do fucking nothing. Motherfucker, what's that shit? Fuck this shit.
Looks like Mr. Souter is on this morning, Your Honor, for a diversion referral. I think Ms. Sweet has executed a speedy trial waiver to accommodate this, and we're just simply asking at this point then for a set over for a diversion confirmation date.
Okay, I guess there was some concern about residents maybe in Idaho, something like that was brought to my attention, but if that's okay with the state.
I spoke with Ms. Sweet about that. I was made aware of that concern as well. Ms. Sweet indicates that he does in fact have a local residence at this time, Your Honor, and so
Okay.
I think that going forward with the referral at this point sounds like the best avenue. If for some reason something comes up, they can address it at the confirmation date, or it can be cited on prior to that date.
Okay, Mr. Souter, then, are you willing to waive your speedy trial rights then in order to accommodate the diversion referral?
Yes, sir.
You realize then that the state will have 90 days from that new date to bring the case to trial. You can't complain that it's taken them too long?
I do, sir.
Okay, what are we proposing as a new commencement date then? May I suggest May 1st?
Is that the date we're going to set over for confirmation, Your Honor?
Oh, well, that's true.
We'll use March 10th.
Should we just use that?
We can use either of those dates, Your Honor. We typically have another speedy trial waiver that's executed at the time of the confirmation if you go forward.
Let's keep them internally consistent then. March 10, 2015, that's okay with you, Mr. Souter?
Yes, sir.
That March 10 date. So that's also going to be the date for your return to confirm whether you'll be able to get it resolved through diversion. March 10. Is that a 1:30?
1:30. That's out of history from Hall.
All right, we'll see you back then.
Yes, I know you're not really helping things. You're running around.
Thank you, Your Honor.
Thank you.
Items number 1 and 9 on the criminal docket is Grayson Christensen.
That's right. here for arraignment.
That is correct, Your Honor. Mr. Christensen has a copy of the information. He understands what he's charged with. He'd like to plead not guilty and waive the formal reading.
And I just have one question with regard to setting up trial dates. On the 14-10-1155-5 matter, he is making first appearance, or he made first appearance on a bench warrant, it looks like. It's unclear to me whether or not we struck the trial date on that one. That would be the older case. And so if those trial dates still remain, it appears we would have 90 days from that date. If we struck it, then we would need to reset both cases.
Sure. He's set for readiness tomorrow on that charge.
So, counsel, your indication is that it was not stricken.
That's correct, and we're going to continue it, ask to continue it tomorrow.
All right, so we're still on for readiness tomorrow, and then the readiness judge can take up that issue at
That is
that time. And that's for I assume that's for a Monday trial date then, February 2?
That's correct, Your Honor.
Okay. So we'll accept the not guilty plea on the new case. This is 15-100-131-1. 2 counts there, trafficking stolen property 1 and possession of stolen property 1. We'll accept the not guilty plea. Out of custody dates, Department 4, we can give you April 13.
That's fine.
April 13, readiness, that's a 75, April 13, readiness April 9. Now, given the fact that the trial date is for this Monday, would that be the commencement date?
It would, well, I think today would be the commencement date. It would be an
Excluded
excluded
time.
period until
Very good.
February 2nd. My suggestion, however, Your Honor, is that if this is on the readiness docket and this is just going to be continued as
Track
the
it
readiness,
tomorrow?
Well, it may simply be, just given the size of the readiness docket, it may be wiser to simply address the continuance on the other case if Mr. Bennett is prepared, and then we can just simply set trial dates today and eliminate the case from the readiness docket.
I think that may make sense. We've got time here, and you're here.
And then no readiness tomorrow?
That would be my suggestion.
Okay, that's fine. Let me do the paperwork.
Is this your motion for continuance?
Yes.
And the basis for the continuance request?
The new charge. And he's agreeable. We've discussed that. He's agreeable to that.
All right, so that's also a Department 4 case. Do we have a schedule, and no opposition from the state on a continuance on the earlier case?
No, Your Honor, I would just ask that we set the earlier case first and that we use the excluded period.
That's fine.
Your client willing to waive speedy trial then?
Yes, Your Honor.
Setting what date as a commencement date?
Oh, 1 March, I would say.
All right, so if we use March 1st as our new commencement date, then we could set
We're going to do that today and not tomorrow.
April 13.
That's fine.
For the older case, that would be a 43-day set. Readiness April 9.
Okay.
And then maybe we should just simply set the same case for trial and readiness on that date.
That'd be fine.
And Mr. Christensen, you're still under whatever release order conditions are in effect.
Yes,
You posted bail and got out, okay?
So there would be no readiness then tomorrow, Your Honor?
I would ask that we strike the dates forward in the other case at this time, Your Honor,
Correct.
based on the new dates we just set.
Agreed.
Correct.
So you don't have to come tomorrow.
Okay.
Make sure you show up for the next readiness date.
Right. Gotcha.
Stops. We just indicate on that one excluded time because of this case. Oh, got it. Thank you. Way ahead of me. Makes it easy for that judge then to see what's going on.
We have 2 of these because you have 2 separate charges. You get a copy. Doesn't look signed. Any questions of the judge?
No. Just I don't have court tomorrow, but
Go ahead, court.
okay. I just want to make sure.
All right, thank you, Your Honor. You're all done.
Item number 16 on the first appearance docket is Jason Workman.
We have Mr. Workman, is who you wanted? Mr. Workman. So right up to that red carpet. You can have a seat. Mr. Myers.
Is your true name Jason Clifford Workman?
Yes.
First name spelled Jason.
Correct.
Middle name Clifford.
Correct.
And last name Workman.
Yes.
Your date of birth?
11/9/74.
And making first appearance this morning on charges of rape in the third degree, domestic violence.
Okay, Mr. Workman, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges that are brought, and you have the right to an attorney assisting your defense. You do qualify for court-appointed attorney. Would you like me to appoint one?
Yes.
Okay, Susan Stauffer. She's going to come forward. Rape 3, domestic violence is the allegation. I'm going to review the probable cause statement.
Good morning. Don't say anything about charges, okay? See. Get it with your mouth. Okay. She, don't look back, but did you see her if she was here today?
I don't.
Okay.
I just got it
Okay.
last night.
She in Vancouver?
Yeah. She didn't even know anything going on. She needs to be contacted.
So your mom's address is 803?
Correct.
Okay.
All right, probable cause established. Position on release.
All right, the state's requesting $30,000 bail plus conditions, specifically no contact order with the alleged victim. Does have criminal history out of the state of Washington that is included privilege of conviction, albeit it's fairly recent from 1997. Does have a history of failing to appear warrants on all 11 cases out of the state of Washington. Supervised release was unable to verify any reference or residence information based on the nature of the allegations, as well as a history of failing to appear. The state would submit $30,000 bill as appropriate.
Your Honor, I would indicate, my understanding is his mother lives here in Vancouver, and he's indicating he can live there. Apparently they tried calling but weren't able to get a hold of her. I'd like to follow up on that. In the meantime, I think, given the nature of the charge and even the PC statement, it's a little iffy here, so I would ask the court perhaps a $15,000 bail at this time, pending additional information for potential supervised release.
All right, thank you. The court considers the factors in Rule 3.2. Both sides make good points. 20,000 plus conditions will be set. Arraignment on February 11, 9 a.m. In the meantime, sir, they're asking for a domestic violence no contact order with respect to Julia Dobby. I'm going to enter that order, sir, that prohibits any kind of contact with her that's direct, indirect, through third parties, electronic. I'll remind you all phone calls at the jail are recorded. You're going to get a copy of this order, but if you were to violate this order in and of itself, that could be grounds for new criminal charges against you. Do you understand?
Yeah, I would indicate, looking at my calendar, it appears I've got two dependency matters up in Stevenson on the 11th. Is it possible to put his case on to the 12th, which would be the Thursday, for arraignment? Okay, thank you.
It's still, well, that's at 15 days.
It's 15. How about the 10th? I
Should be
apologize.
fine.
I just
Tuesday morning docket?
never know when we're going to.
I'll defer to the court.
Yeah, let's do February 10, then we're within speedy arraignment.
I'll get someone to cover on the other one. But for most of the
Counsel, there's a no contact order.
Okay, we'll go back and have a chat. Did you sign that? Let's see here. Okay, we'll sign there. grab those. And let's go back. Thank you.
Item number 4 on the criminal docket is Stephen Meyer.
I call him Meyer. Apparently wrong.
Good morning.
Good morning, Your Honor. This is Mr.
Good morning.
Meyer. Stand right here.
Morning, Your Honor. This is state's motion for continuance. The primary officer in this case, Officer Gelsinger, is unavailable on the trial date. It's a little bit weird because we knew about that when the trial date was set. I was not present. The docket deputy did it, so I'm not sure why it was set on the state, if that was intentional by the court. I had no notes on it. Officer Gelsinger is out of mandatory training from 128 to 27, so he will be out on the state. He is unavailable a lot over the next 2 months. I'm not sure what the trial dates are, but...
Any objection to the continuance?
I was waiting for it. You finished?
Basically, he's not available for mandatory training date. The training was scheduled before this trial date was, so for that reason, the state would be asking for continuance.
We're at 27 days, just so you know. Any objection to the requested continuance?
Yes, Your Honor. We do object to the requested continuance. First of all, we don't think this is a necessary witness, a material witness in the state's case. He did not observe any of the actions that are being charged in this case, and we feel like they can prove their case without him. The second thing is that we have been asking for interviews on this case for the last month and a half. Apparently, the prosecutor just informed me this morning that they have an idea of where the victim is located now, but we still have had no contact with her, and we've already waived one time to enable us to do an interview, and now we're just not getting anywhere. So we're objecting to the continuance request this time.
There's a third issue as well. It was also accidentally set on a non-trial date.
Oh. Well, that's kind of the trifecta then. We've got witness unavailability, some discovery issues, and a erroneous trial setting. Based on the previous waiver, we still got plenty of time within Speedy. We're going to give you a March 2nd trial date. That's at 53 days using the date of commencement of January 8th, 2015. March 2nd.
The officer is unavailable on March 2nd as well. And March 4th, it looks like available on March 3rd, so I suppose I could always call him that.
March 4th would be an available date. We could give you a trial date on March 4th. That's a Wednesday short trial week.
Let's do that. He's available on the 5th, so I can always call him on that second.
Okay, March 4th is still within Speedy. That's a 55-day set using the January 8 origination date. February 26, 1:30 for readiness. I guess, was it 55?
Was the readiness taken? I'm sorry.
Readiness, February 26th. March 4 trial date. March 4 is 55.
Your Honor, would the Honor be receptive to some, especially say in light of another continuance in this case, be receptive to re-talking about bail in this case?
Well, I don't have a written motion. Does the state object to the court reconsidering bail at this time?
Yes, Your Honor, there hasn't been a change in circumstances. There's no written motion.
Well, I haven't heard that yet, but...
I mean, that I'm aware of, I should say.
Okay, well, we don't have a written motion, but since we're all here, let's take a look at it. Do you have the file?
Yes, sir.
Sorry about that. Looks like bail was set at $20,000 at first appearance. Go ahead then, Mr. Peterson.
Your Honor, Mr. Meyer has literally lived here all his life. He's got a job, and we have had no contact with this victim. He has no felony history at all. And the way this thing is going is it's being strung out over and over and over again. And I don't, personally, when we come in on first appearance, we look at the affidavit from the officer who takes into account the victim's statement. But to be fair, as this case is drug on, those statements and the validity of this victim's statements, to me, have gotten less and less credible. She's been repeatedly tried to be contacted, not responding, can't find her, and yet Mr. Meyer just keeps sitting here in jail. I think that it's much more fair for Mr. Meyer to have the benefit of the doubt here and say, look, we have a trial date set, and that's what it's for, to figure out these differences of opinion and testimony. But as far as his conditions of release, I think that as this case is drug on, I think $10,000 is much more appropriate in this case, which is what it would have been, when it first came in, and then the prosecutor changed it to a different charge later. So I would be asking for $10,000 bail, Your Honor.
Your Honor, let me know when you're ready. Sorry.
Go ahead.
The state objects to that. First of all, looking at the defendant's criminal history, while it is mostly misdemeanor, he has multiple priors from different states, from Washington, from Alaska, from Minnesota. He has warrants on 7 prior cases in Washington alone, PVs out of other states as well. As defense has pointed out, when bail was set, this was actually an unlawful imprisonment. It's now an indecent liberties with forcible compulsion, which is a Class A felony. The charges have gone up. I don't believe it's accurate, too, though the witness has been avoiding us. We actually, to be candid with the court, we were missing part of her address, so we were having trouble looking at her. We fixed that. We found it. We now know where she is. I don't believe it's appropriate to say that her statements in the PC statement are less credible somehow because of that. There has not been a change in circumstances. In fact, the charges are much more serious than they were when bail was initially set down at $20,000, and so the state would oppose bail being lowered.
Well, and I look at that first paragraph in the PC statement. There's some public safety, or certainly safety of the alleged victim concerns. I tend to agree with the state. If anything, the court feels reinforced in the setting of the $20,000, so no change in bail.
Here.
Item number 4 on the first appearance docket is Larry Haas.
Good morning, Your Honor.
Good morning.
This is Mr. Hawes. This is a Department 9 case. We're here to quash the warrant. There was a readiness hearing on Thursday. My client didn't appear. He did appear on Monday at the trial, came to court, was told the trial was struck, went to the prosecutor's office, and immediately called me. As far as missing court on Thursday, there was, a combination, almost a comedy of errors going on. He had just obtained a new job a week and a half ago, and I'd been reaching him at his work previously. His sister, who had all his court documents, was in Seattle and so he couldn't access the documents. His dad was in the hospital.
Yeah, my dad had a kidney transplant, and I was in the hospital. His kidney wasn't functioning, so he's in the hospital for about a week.
And obviously he didn't have my phone number, which was on his phone, and I don't know why, but he couldn't remember how to spell my name, apparently. So anyway, so we're here to reset the trial date, quash the warrant, and move on.
Your Honor, if I could just first address the identifiers, because he is making first appearance on a bench warrant, technically. Is your true name Larry Clarence Haas?
Yes, ma'am.
First name spelled Larry?
Yep.
Middle name Clarence?
Yeah.
Last name Haws?
Clarence Joseph, actually, but yeah.
And your date of birth?
4/27/89.
Your Honor, I'm going to let Ms. Duncan, who is the assigned DPA, address the warrant as well as the additional motions made by counsel.
Your Honor, at this time, obviously, he's here, so no issue with the warrant being quashed at this time. I have spoken to Ms. Cloutier, saying that name?
Yes.
Sorry.
Perfect.
And I understand the reasons. The state will not be ending bail jump at this time. We have let the defendant know that that's still a possibility going forward, but at this time, I'm not asking to be taken back into custody. We'd just like to set dates going forward.
All right, so we will quash the warrant then. Mr. Haas, people, as my father used to say, everybody screws up once in a while. You sort of just used yours, so don't let it happen again, all right?
Yes, sir.
I understand you may have had circumstances, but we've got wheels that are set in motion when we have trial setting and readiness and whatnot. So I think it's pretty generous on the state's part, at least at this point, not to ask for any sanction, or at least not asking for additional bail jumping at this time. We're in Department 9. We're going to give you some trial dates. What's our commencement date then, given, is it today?
I think it would be today, yeah.
All right, so we're out of custody. We can give you April 15. That's a Wednesday trial set, short trial week, but that's okay. April 15, readiness on April 9 at 1:30.
And I will just put on the record that I don't have officer availability out that far, so if there are any issues, I will bring it back before the court.
What did I say? That's April 15 is a 77-day set, sorry.
That's tax day, right? So it's a good way to remember.
Okay.
But the 9th as well. So that's on Thursday, 1:30. So you'll sign a document, keep a copy of that. Don't leave because I want to talk to you for a minute, okay? Thank you, Your Honor.
Thank you.
We just need the defendant's signature.
Okay, sign there. Okay, so I'll give you a copy of this.
Thank you.
Item number 8 on the first appearance docket is Gregory Gordon.
Sir, up there, card face the judge only.
So true name, Gregory M. Gordon.
Yes, it is.
First name spelled Gregory.
Correct.
And your middle initial M. What does it stand for?
Michael.
Michael.
Yes.
And last name Gordon.
Correct.
Your date of birth?
March 20th, 1993.
Thank you for appearance this morning on charges of assault of a child in third degree.
Okay, Mr. Gordon, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges that are brought, and you have the right to an attorney to assist in your defense. You do qualify for a court-appointed attorney. Would you like me to appoint one for you?
No, thank you. I have one in mind already.
Okay, so you're declining a court-appointed attorney. You intend to hire your own attorney?
Yes.
Okay, one moment then while I review the probable cause. Okay, probable cause established. Position on release.
Here the state's requesting $50,000 bail plus conditions, specifically no contact order with the alleged victim. Does have criminal history, albeit it appears that it's all from inside Maryland. 2 convictions for theft from 2014, as well as a burglary from 2011 and a theft in 2010.
Those are Washington?
Those are all from Maryland.
Those are
Your
all from
Honor.
Maryland, okay.
And I address all of them simply because it does appear that he does not have local ties to the local community. The state does have some concerns about that. Does have verified reference information. Residence information is it's unclear whether or not that's been verified. It does look like the prior residences with his girlfriend, which may be with the alleged victim. Again, I'm not completely clear on that from the information that I have at this time. The state would obviously object to that. For those reasons, Your Honor, based on the nature of the allegations, the state would submit that $50,000 bail plus conditions is appropriate.
Mr. Gordon, do you wish to respond to the state's bail request for $50,000?
Yes, please. I have no prior convictions that I know of. I've only been to Maryland maybe once in my life in 2011 or 10. Other than that, I have not been on the East Coast for a while.
All right. Anything further?
The current address, there's also a prior address before that with my mother, but there can be other addresses provided if necessary for me to stay at.
All right. Given some of the history and given the nature of the charges and the other factors in Rule 3.2, the court's going to set bail at $30,000 under the circumstances. You will set your arraignment over to February 11 at 9 a.m. and also to confirm counsel. So if you intend to get an attorney, I strongly suggest you get your attorney on board by that hearing date, okay?
May I write that down, sir?
You're going to get a, so you're going to get anything with the arraignment date? $30,000 we set as bail, arraignment February 11, 9 a.m., and to confirm counsel. Okay, so you've got that there. The state's also requested, and I'm ordering a protection order, no contact order?
No contact order, Your Honor.
No contact order with respect to the alleged victim.
May I read this first, please?
Absolutely.
The first page of it is.
Your signature is just an acknowledgement that you've received a copy of that. and you understand that that's what the court is ordering. So if you were to violate that order in and of itself, that would be grounds for new criminal charges against you, sir. So the child that's alleged is the victim, absolutely no contact, direct, indirect, through third parties. All the phone calls at the jail are recorded, just so you know. You'll get a copy of the order. It's very, very broad and sweeping. If you have any questions, you should talk to your attorney about it.
Item number 7 on the first appearance docket is Michael Fusilio.
Sir,
You're all set.
Red card, sir, face the judge.
Searcher named Michael Nolan Fusilio.
Fuccio.
First name spelled M-I-C-H-A-E-L.
Yes.
Middle name N-O-L-A-N.
Yes, it is.
And last name F-U-C-C-I-O-L-O.
That's correct.
And your date of birth?
10-2-67.
Thank you for appearance this morning on charges of possession of a controlled substance, methamphetamine, and possession of a controlled substance, PCP.
Okay, Mr. Fucciolo?
Yes, sir.
Mr. Fucciolo, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney to assist in your defense. Do you have your own attorney at this time?
I was told I qualified and was
You
going
do qualify for court-appointed attorney. Would you like me to appoint one for you?
Yes.
Okay, Susan Stauffer. She's going to come forward while I review the probable cause.
Good morning.
Good morning.
Okay, sorry.
Okay, probable cause established. Position on release.
Your Honor, the state's requesting $5,000 bail plus conditions. It does appear that he has criminal history out of the state of Washington, albeit it appears mainly misdemeanor history. However, does have a history of failing to appear. Supervised release was unable to verify any reference or residence information. Looks like a prior residence listed was in Portland for approximately 2 months. The state has some concerns about his connections to the local community. For those reasons, Your Honor, the state would submit $5,000 bail is appropriate.
Your Honor, I would indicate he apparently has his own place to live at, and he apparently has some ties to the community, so I'd ask for a $2,500 bail under the lack of a substantial criminal history.
I think given the factors there under Rule 3.2, 5,000 is reasonable as requested. Set over to the 11th at 9 a.m. for
We
arraignment.
have that on the 10th, Your Honor.
I'm sorry, 10th
Okay,
at 9 a.m. for arraignment.
I'll talk to you back here. Thank you, Your Honor.
Item number 6 on the first appearance docket is Zachary Henderson.
Mr. Henderson? Put up to that red carpet, please.
Search your name, Zachary Dalton Henderson.
Yes.
First name spelled Z-A-C-H-E-R-Y.
Yes.
Middle name D-A-L-T-O-N.
Yes.
Last name H-E-N-D-E-R-S-O-N.
Yes.
Your date of birth?
5791.
Thank you. First appearance this morning. A bench warrant issued for an information filed for possession of controlled substance methamphetamine. I am providing him a copy of that information.
Okay, Mr. Henderson, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges, and you have the right to an attorney appointed to help in your defense. You do qualify for court-appointed attorney. Do you want me to appoint one for you?
Yes.
Okay, Diane Greco. She's going to come forward while I review the probable cause. I don't have...
I'm sorry, the gentleman's name again? Henderson?
Is Mr. Henderson. I don't have the PC statement.
Your Honor, I think probable cause has been previously found,
Pre-filed?
because it's a pre-filed matter.
Do we have a file on that then? Henderson. All right, probable cause previously established, possession of controlled substance methamphetamine, position on release.
Your Honor, the state's requesting $10,000 bail plus conditions. It does appear that he has criminal history out of the state of Washington. It looks like the most recent conviction would be from 2013, a possession of a controlled substance charge. Does have a history of failing to appear, at least 4 prior warrants having been issued for his arrest. I don't have any information whether or not supervised release was able to verify any residence or reference information. For those reasons, Your Honor, the state would submit $10,000 bail as appropriate.
Ms. Greco?
Judge, I think we'll reserve at this time.
Yeah, I think given those factors cited by the state, it does warrant the little bit of extra. So the 10,000 seems reasonable. Set over to the 11th at 9 a.m. for your arraignment. That'll be your next court hearing, sir.
Judge Collier has docket on February 4th and 5th.
This is a Department 10?
Yes.
All right, that's good then. Let's do February 5th.
Are we changing it?
Changing arraignment to February 5th because it's a Department 10 case.
Okay.
Which, wait a minute, that may mean you're not in that group, are you?
No.
My apologies then. Let's appoint Steve Rucker. My bad.
Okay.
And I apologize, Your Honor. I didn't realize that it was a Department 10 case when I called in.
We're going to get you a slip of paper with Mr. Rucker's name and address and phone number. He's going to be notified that he's been appointed as your attorney, and he'll be here for the arraignment on the 5th as well.
Okay.
Okay.
He can deal with it on the 5th. That's just next week.
And Mr. Rucker owes you one, Mr. Greco.
Okay. You can go back.
Okay.
Well, we're going to give him
Stay right here.
Oh,
We'll
does
get you
he
that
get
slip
him
of
more
paper. Okay.
information? Okay.
So will this affect my DOC? Because I
You'll
was
have to
just here
talk to
last month.
you'll have to talk to your attorney about that. But you'll have his phone number. You can contact him today if you want.
Your Honor, if we could recall item number 7 on the first appearance docket, Michael Cutulio.
Your Honor, my client's indicating that he's going to be planning to bail out this morning. He has a court hearing this afternoon on a custody case, so I'd ask the court to authorize setting of conditions at this time.
Will you do that, please, Ms. Welsh? Go ahead.
Thank you, Your Honor. So she's going to talk to you about conditions.
Item number 18 on the first appearance docket is Jeffrey Andrews.
Mr. Andrews. Sir, right up to the red copy face of Judge Owens.
Good morning, Your Honor. Mr. Andrews is here on a civil contempt matter where he failed to appear at a review for child support. This time the state is asking that he be released in order to return to court next Tuesday, February 3rd at 2 p.m. to pay the $200 and provide his job log.
Okay, do you understand what the state's requesting, Mr. Andrews?
Yes.
They want to let you out today on condition and promise that you come back Tuesday at 2 o'clock.
I am.
You going to do that?
Yes, and I do have it's an under the table job, and I got a regular job that's.
Okay. Well, it sounds like they're needing a payment of $200 by then. We're going to sign an order releasing you on this warrant with that understanding.
Just a second, I'll get your copy. there's your copy.
Thank you.
Thank you, Your Honor.
I think we're just waiting for supervised release to go over that release order, Your Honor. I'm not aware of any other out-of-custody matters that are ready to go at this time. I think we're just waiting for the next review of custody to arrive. Is Mindy Duffy present? Have you had contact with Miss Ruley this morning?
So when they have that TV pool and put it all in the same spot. I assume. Exactly. I assume that was all run with you, but I never actually hear that process. But. I had a text last night from Charles. I didn't realize it was going to be a full team. Oh, really? You knew we were going to get it?
Recalling item number 7 on the first appearance docket.
All right, Mr. Picciolo, have you gone over the release order conditions with the supervised release
Yes, I
officer
have.
here, Ms. Welch?
Yes.
You understand that if and when you post your $5,000 bail bond, then you'll be released on these conditions while your charges are pending trial. You understand that?
Yes.
If you violate any of these conditions, your release can be revoked. You can be brought back into custody. You understand that?
Sir.
Let me go over some of these then here. All of these apply, but I just want to cover some specifics. First, don't just walk out the door over at the jail. Check in with supervised release office. Follow all the reporting instructions. You are not to go to the address there in Portland, Oregon. You're to live at the address there on Reserve Street in Vancouver and make all your court dates. When's your next court date, sir?
It would be the 11th?
I think it's the 10th.
It was changed to the 10th.
Oh, it was changed, okay.
February 10th at 9
Okay.
o'clock. It'll be on
Okay.
your papers. Don't forget that.
All
You
right.
got my card.
Yes.
Keep in touch with me.
If you were not to show up at your court date, that's not only a violation of this order, that is new crime of bail jumping for which you could be charged. Do you understand that?
Yes.
So when you get out, call me. Just leave a message that you're out and
Will I
about.
be able to be bailed?
I don't know. It depends on
Can I ask?
depends on how quickly you get hold of the bail bondsman.
Can I ask if it's possible?
It depends on how quickly they post the bail and how quickly they process the paperwork. You may or may not be able to get out. Okay?
Your Honor, I do have a couple matters that are not on docket. If Your Honor would be willing to sign orders of exoneration on, I have a Stanley Castro and Estacio. And Lisa Bella Badanin.
Today? Which courtroom? Yeah, I'll watch you. Go off record?